Thank you very much, Director Bettina, for this opportunity to comment on some issues that have been addressed by the panelists and also maybe some questions that have emanated from the audience. My name is Mark Barasa, Senior Assistant Director of Public Prosecutions in the Office of the Director of Public Prosecutions in Kenya. Yes, I indeed confirm that we do have a case filed before the High Court in Kenya. This case is brought under the International Crimes Act of Kenya, and in the case we seek to hold police officers accountable, police officers who held command responsibility, who had command responsibility at that time when those alleged atrocities were committed after the 2017 general elections. I do confirm that there have been challenges to the decision to charge by the Director of Public Prosecutions. Judicial review applications have been filed in the High Court, and the High Court has ruled that indeed the DPP was right in making the decision to charge. Of course, the parties have moved to the Court of Appeal to challenge the decision of the High Court, which held that the decision to charge was lawful. So we do not know what the Court of Appeal will say. If the Court of Appeal states that the DPP was wrong in making the decision to charge, again, that will be a huge setback. Of course, we have opposed that judicial review application, but the case is pending before the Court of Appeal. It might go all the way up to the Supreme Court before Honorable Justice Lenaola. So in the High Court, the trial itself is pending. It is coming up on 3rd of March. The High Court had made several orders. When the case came up for plea, we raised an issue because one of the accused persons was absent. He was not present in court, and therefore the court granted our request for 30 days to have the plea deferred so that a report can be filed by the Inspector General of Police concerning efforts that have been made in tracing that one suspect who was not present in court. The court, of course, evaluated the procedure before the International Criminal Court at The Hague and the procedure before the Kenyan courts, as learned colleague Tina rightfully said, and the court held that the procedure to be followed should be the Kenyan criminal procedure, the procedures provided for in the Kenyan Criminal Procedure Code. And therefore, the accused person has a right under Article 50 of the Constitution of Kenya to be present in court. And the court stated that all efforts to ensure his attendance in court must be exhausted before we can proceed. And therefore, on 3rd of March, the DPP will be evaluating that case afresh because this is a case that involves command responsibility. What was the role of that missing person? In the event we amend that charge to have him removed from the case, how will that affect our case altogether? So we are evaluating the entire situation. We are alive to the fact that the case against Lohan Bagbo in the DRC was dismissed after around 3,000 people died. The case against Blegude and, Bemba was in DRC, Blegude and Lohan Bagbo was also dismissed. So this kind of cases where you seek to hold people accountable under the concept of command responsibility, you really have to be very careful and ensure that your case is watertight, the way, like in the AKS case at the ICTR. So we don't want to let the victims down. Of course, we've had spirited efforts by the defense counsel and also the victims' lawyers to have the case proceed. I can say that it is a very interesting case, and we are doing our best to ensure that we don't let the victims down. So that is all I can state for now. Thank you very much.